Well, good morning, everybody. This is Brian Dayton with the West Virginia Chamber of Commerce. I want to thank everybody for joining us today. We're now just a couple of weeks away from the end of 2020, and I think all of us will be more than happy to welcome 2021 and hope for a much better, more calm year ahead of us. But with the coming of the end of the year for the employer community in West Virginia, there were several things related to COVID-19 and potential challenges that employers are going to be facing. So we have with us today Bryan Cokeley and Mark Dean from the law firm of Steptoe Johnson to talk about some of the issues employers are going to be facing. And I know both of them have been up late working because, as you may have seen in the news, Congress is actively working on a COVID relief package. So we are hopeful that such a package can pass. But before we kick it off, I just wanted to briefly introduce our two speakers. First up is Bryan Cokeley. He has been with the law firm of Steptoe Johnson. He has headed up their employment law division for quite a while. He's a problem solver. He regularly counsels clients on a wide variety of issues. And, in preparing narratives for juries, he's inspired by his farmer father, who had the folksy wit of Will Rogers. And I know Bryan, and he definitely does. I always enjoy the stories whenever you call him for an issue. It's always enjoyable. The other person with us today is Mark Dean. Mark is actually a former roommate of mine through college and grad school, so I know him quite well. I'll go ahead and do the professional biography for Mark. I'm sure he would appreciate that. But he has been with the law firm of Steptoe Johnson for a number of years now, practicing labor and employment law, and he regularly represents employers both in the public sector and the private sector. So we are very pleased that both of them have volunteered to come forward today and talk about this very important issue. So without further ado, Bryan, Mark, I'll hand it over to you.
Well, thank you very much, Bryan, and thank you to the Chamber for the opportunity. And good morning to folks out around West Virginia. And if it's snowing or has snowed where you are, I hope you're safe and sound. We are at an interesting point on the calendar. As Bryan indicated, we are halfway through what has been a challenging year. The beginning of 2021 promises to also be challenging. We're also coming up on the holidays. We're coming up on a couple of federal laws that a lot of you have been very familiar with are going away here at the end of the month. We've got a lame duck Congress that, as Bryan indicated, is at work right now on a stimulus package. And we have a new administration coming in. And in case you haven't noticed, we also have a Georgia Senate runoff down on January 5, I think it is. So, and a new administration coming in on January 20. So there's just a lot going on. Let's just kind of review where we are right now. Mark's going to be talking a little bit about the FFCRA and the two leave acts that are embedded within that March law, and what's happening to them at the end of the month. They are sunsetting, it appears. We have vaccinations that are being rolled out, and then we've got all this uncertainty as to what's going to happen in Congress and at the West Virginia legislature. Of course, unique to West Virginia, perhaps, is that we have a delayed legislature. It will not come into session in January, but rather it will be in early February this year. So, Mark, why don't you just briefly review where we've been with the two leave acts under the FFCRA, the Families First Corona Response Act that President Trump signed into law back in March.
Okay, thank you, Bryan. I'd be happy to do that. And again, thank you to the Chamber and to everybody tuning in today for giving us this opportunity. I'm not going to spend a whole lot of time on these two leave acts that were embedded in the FFCRA. We've been living under this paradigm now since April 1st, and we're only going to be living under it for about 2 more weeks. But just to set the stage for some of the issues that we're going to be talking about today, embedded within the FFCRA that was enacted back in April were two actual separate leave provisions, even though they work in concert, and we've been analyzing them hand in hand together. The first is the Emergency Paid Sick Leave Act, which requires employers of under 500 employees to provide 2 weeks, or really the equivalent of 80 hours of paid leave if an employee is unable to work because of certain COVID-related conditions, whether they are quarantined either by government order or by the advice of a healthcare provider, they're experiencing symptoms and seeking medical diagnosis, caring for an individual who is quarantined, or they're caring for a child whose school or place of care is closed, or they were otherwise unable to get child care for their child because of the virus. The other was an emergency expansion of the existing Family and Medical Leave Act, FMLA, and that added a new category under FMLA where an employee can get up to 12 weeks, 2 weeks unpaid, and then 10 weeks paid if they are caring for their child whose school or place of care is closed, or if they cannot otherwise get child care due to the coronavirus. I mentioned before that we've often analyzed the emergency paid sick leave and the emergency FMLA in concert because they do work together. The emergency FMLA can run concurrent with other leave, be it leave under an employer's existing policy, paid time off, sick leave, or those first 2 weeks can also be covered by the EPLSA. But as we mentioned, these are going to be sunsetting very soon. And I'm going to hand it back to Bryan to cover what's going to happen here in a couple weeks.
You know, I'm probably like a lot of folks who thought that this pandemic would be over by the end of May, or certainly by the 4th of July, or if we could only make it to Labor Day. And now here we are at the end of December. Obviously, Congress and the administration back in March thought that they only would need to have these new leave laws on the books until the end of this year. There's been a lot of speculation in the last several weeks as to whether Congress would extend the Emergency Family Medical Leave Act and this Emergency Paid Sick Leave Act. As of this morning, it doesn't appear that's going to happen. Now, stay tuned. We were surprised back in March as to what popped into the legislation at the very end. So anything could happen today or tomorrow, but this lame duck Congress is set to adjourn. And it appears that the stimulus is all about unemployment, which we'll talk about that in a minute. And it's about direct payments, and it's about stimulus. So it's just really all about money. I don't think Congress has gotten down into the weeds and address this FFCRA. Again, stay tuned. So it looks like it's going to expire at the end of December. And keep in mind what Congress did back in March. For those of you who have fewer than 500 employees and have taken advantage of this act for your employees, you know that in essence what you have been is the middle person in a business transaction, because you are extending the leave benefits on the front end, and then the federal government has been paying for them on the back end. Will come to an end. It won't necessarily come to an end right on December 31, because if your payroll lags, you can obviously wages that you're paying into January, you can still get tax credits for. But there's a lot of uncertainty as we bridge the gap, which we've never done on the federal level before, for paid federal leave and into a situation where that's taken away. So let's take a look at just some of the issues that you may be dealing with here as we go forward. Again, the sunset situation. So what happens if an employee begins their leave next week or the day after Christmas? What happens to that leave on December 31? It's essentially going to go away. If you have an employee who's out on leave because of a COVID situation and they're qualifying for pay, that right's going to end. Now, by your grace, you can continue to pay that employee, give them paid leave, but you're not going to be able to get tax reimbursement or reimbursement through tax credits and what have you on the back end. So you need to keep that in mind. You know, it's one of the things that occurred to me as I looked at this sunset with regards to the way the FMLA was extended. such that, that employees who have childcare or school issues can get extended FMLA and can be paid for that, which up until this year, FMLA has always been unpaid leave. But there's a wrinkle in there in that it's unlikely that you're going to have any employees who are on the emergency FMLA leave because of a school closure or childcare at the time that this goes away. And that's just because of the fluke of the timing of it. December 31. Schools aren't going to be open on January 1. A lot of them aren't open right now. You're not even having virtual schooling. So they're not closed. They're not closed because of COVID. They're closed because of the holiday. So you're unlikely to have a situation where you're taking leave away. They're not going to be entitled to really COVID-related leave because of school closures or child care issues. Well, maybe on child care issues, but certainly not school. One of the things that I think employers need to pay attention to is that if employees sense that there's a bank out there and they want some time off for the holidays, you're going to have to monitor that, because one of the things that may happen in 2021 is that the IRS may take a look and start auditing all these requests for refunds and rebates or tax credits, and you need to have documentation, and you need to either have medical documentation or documentation with regards to child care. So what about an employee who is quarantined or infected after December 31? What are you going to be able to do with those employees? Some of you have been using the FFCRA as a tool. It's part of your toolbox to help employees. You're not going to have that in your toolbox. The same situation with regards to school situations. If an employee needs to be home because of a school closure, how are we going to deal with that come January? I mean, this virus, it's going to get worse before it gets better. So how are we going to deal with that? And then finally, how do we deal with the fearful employee? I would suggest to you that we are in January and February, we're going to be right back where we were in March. We're going to be back before the FFCRA came along. And when you have an employee who is infected or has had an exposure or has to quarantine or they've got a school situation, you're going to have to either do vacation, sick leave, PTO, or unpaid leave. You're not going to have the federal paid leave situation. You're still going to have to deal with these situations. You may have a situation where employees are they've been comfortable working remote, or they have a heightened concern about coming to the workplace. So how are you going to deal with those situations? I have been reluctant, and I was back in March, to tell employers to just say, well, you don't have a job, you're terminated. You might get to a situation where you have to say to an employee, look, the job is here, we're working, we're open, we'll put you on an unpaid leave, and unless they have a disability or something, some other right under state or federal law, it may be an unprotected leave. And you can say to them, you're on an unpaid leave of absence, we'll check back in with us come April, May, and we'll see where we are. That way you avoid putting the stigma of termination and so on. They may still want to, at that point, claim a furlough and apply for unemployment, and that's fine if they want to do that. So, Mark, why don't we talk a little bit about discrimination and retaliation, because I think there's going to be a fair amount of litigation, unfortunately, in 20 and 21 with regards to decisions that were made in 2020 with regards to employees.
Yeah, thanks, Brian. The FFCRA does, by its own terms, incorporate anti-discrimination and anti-retaliatory provisions within the Act. Now, one niggling question out there is, if these anti-discrimination provisions are incorporated within an act that by its own terms expires on December 31st, then don't those go away as well? That might be a tempting position to take, but I really don't think that is going to be the case. Although the leave expires, I think that we are going to be facing some anti-discrimination, anti-retaliation litigation. Just because the leave expires doesn't necessarily mean that the protections are going to as well. And I would point to the FFCRA actually incorporates two different schemes of discrimination and anti-discrimination and anti-retaliatory provisions. As far as the emergency paid sick leave goes, those first 2 weeks, the 80 hours of paid leave, the DOL has authority to enforce that through the Fair Labor Standards Act, the FLSA. And what the regulations say is that if you fail to properly provide those benefits, then the FLSA kicks in. If you fail to provide it at all, then you are deemed to have failed to pay the employee the minimum wage. And of course, the FLSA has its own anti-discrimination provisions. As far as the emergency FMLA expansion goes, because that added essentially a new category to the FMLA, that enforcement scheme is through the FMLA itself. And both of these have a 2-year statute of limitations, 3 if it's considered malicious or willful. But there's no mention of any statute of limitations in the FFCRA itself. So to the extent that the FFCRA has adopted these enforcement schemes, I think employers are still going to be accountable for decisions made between April and December, even after the FFCRA has expired. As far as other issues that have been brought up by the pandemic is issues of unemployment compensation. And again, I just really kind of want to set the stage for where we're at and where we're headed, because this could be a world unto itself. Back in April, as part of the CARES Act, the federal government provided, of course, enhanced payment benefits to employees who were claiming unemployment as part of due to the COVID virus. Originally, that was $600 fully funded by the federal government on top of your normal state benefit level. And that, again, I think Congress did not expect the pandemic to continue this long. Those ended, that $600 payment sunsetted in July. The next month, President Trump entered an executive order allowing FEMA, the Federal Emergency Management Administration, to release grants to states that would provide some extra funding at the level of $300 a month on top of state benefits. The state could also kick in an extra $100 from its own fund. West Virginia has done that through the pot of money of CARES Act funds that it has received. But again, that was more of a grant program, and the federal extra $300 ended in September. So we are back, at least as far as benefit levels go, we are back to the standard state benefit level, even for people affected by COVID, with the caveat of the extra $100 that West Virginia has been kicking in. Part of the CARES Act was pandemic unemployment assistance, and this loosened up a lot of other things. It extended the unemployment period from 26 to 39 weeks. That just recently ended, and it also started encompassing for the first time part-time workers, independent contractors, freelancers, not strictly employees under the unemployment compensation scheme. And of course, it also loosened up job search requirements that you have to prove that you're searching for a job while you're on the pandemic unemployment assistance side of unemployment, which has run concurrently with the standard. This is another avenue, but as you can see, it's starting to close down. Some things for employers that happened is at least in West Virginia, if you have an account with Workforce West Virginia and you are covered by the state system, employer experience rates determining your rate to pay into the system for 2021 have been going out over the past week. I've been informed that, at least in theory, any claims due to COVID should not be counted against an employer's experience rating. Self-insured employers have been in a slightly different boat. The CARES Act has funded 50% of benefits for self-insured employers, but again, that is coming to an end here shortly as well. As I mentioned, a lot of this came through the CARES Act, which is sunsetting on December 31st. West Virginia has backfilled a lot of its unemployment costs with CARES Act money. As I mentioned, as part of the extra unemployment benefit that began in August, West Virginia was one of 4 states that kicked in $100 on top of the extra $300 from FEMA. They have continued to do so even after the FEMA money ran out. But the future is uncertain. CARES Act money, as has been widely covered in briefings, essentially expire on December 31st. If that money is not used, it has to be returned to the federal government. So as we have kept saying, this pandemic has gone longer than we have expected. After January 1st, there will still be unemployment claims, but the existing pot of money and the existing provisions will have expired. So what is next? And we'll get to that a little bit more in a minute, but that's really what's going to happen on the unemployment front is going to rest on what Congress decides to do in the next few days and perhaps what the legislature decides to do in February. So that pretty much sets the stage for where we are in this pandemic and what is existing right now. And I'm going to kick it back to Bryan to share about where we're headed.
Thank you, Mark. Before we do that, let me circle back just briefly to sort of the scenarios or some common scenarios, January, February, March, as we go into what's going to be a pretty rocky first quarter. And we're going to have employees wanting time off or refusing to come back to work. We may have folks struggling with school closures. Again, keep in mind the checklist. Does the employee have vacation? What's your vacation policy? So remember to look first to your policies. PTO, sick leave. Can you help your employees with some paid leave? If it's a disability situation involving the employee, and you need to look closely at that. If you get into a medical situation, even though they're out of sick leave, maybe they're out of vacation leave, under the ADA and the West Virginia Human Rights Act, they may qualify for an unpaid extended leave as a reasonable accommodation. And you only get into that if they truly have an underlying disability. You need to get off of automatic mode that, well, they've exhausted their vacation, they've exhausted their sick leave, there is no more benefits for the employee. There may not be any paid benefits, but again, they may be entitled to some type of an unpaid leave because of an underlying disability. You have counseled a lot of employers who have had situations where employees are fearful about coming to work because of who lives in their household. I live with my mother, or I live with my my daughter who has underlying health conditions. She's at risk. I don't want to be coming and going. That's a tough situation. Understand that under the law, under the disabilities law, you have a duty to accommodate the disability of an employee. You don't necessarily have an obligation to accommodate the employee because of someone else's disability. That employee is protected from what's called associational discrimination. That is associating with somebody who has a disability. But you don't have to accommodate the disability of someone else who's not your employee. So that's something to keep in mind. Also under OSHA and the NRA, if a workplace really becomes a real problem, a real danger, understand that employees have the right to engage in concerted activity. They have the right to speak up. They have the right to complain. Pretty high burden under OSHA to refuse to come to work because of an unsafe workplace, but it's out there and you need to keep that in mind. Mark, we're going to go now into what is really sort of the subject of the hour, and you're going to be getting a lot of information on this. And in fact, the Chamber, perhaps in early January, will be coming back to you with some more offerings and some more content with regards to vaccines and vaccination policy. Why don't we jump into that, Mark, with the next slide? Why don't we, some of you are struggling right now. Do we go voluntary? Do we go mandatory? Should we have a vaccination policy? I'm of the opinion that even if you opt to have a voluntary vaccination program or policy, you need to have a written policy. I would recommend that. So what are we hearing from around the country with regards to voluntary versus mandatory policy? First and foremost, it depends upon the industry. If you are in the business of being a first responder, if you're on helicopters flying in and into situations, if you are such as an air vac type company, if you are a small hospital or a nursing home, we see a lot of healthcare providers who are going to mandatory policy. But some employers are holding back. They're watching the medicine. And here's a point that bears mentioning. And there's been some publicity about this. I think everyone's excited about the vaccines coming on. I think Moderna maybe tomorrow. West Virginia has had shots administered. It's a wonderful thing. And I don't want to in any way put a damper on that great news. It's wonderful. It's the beginning of the end, I believe. But keep in mind that we just don't know a few things about these vaccines. We know that they're safe. That seems to be the conventional wisdom. I'm hearing a lot of smart people talk about how safe they are. They seem to be effective with regards to the person who's receiving the vaccine. One of the things we don't know is whether you will have sterilizing immunity from these vaccines. That is, that you cannot get infected, or whether you will have effective immunity, meaning that you yourself will not get sick. In other words, it prevents sickness rather than preventing you from getting infected. And that's important to understand with regards to where we may be in the next 2 or 3 months. Because of that unknown, I will not be advising employers and within our own office, I will not be telling folks, don't mask up. You don't have to worry about social distancing. We can go back to having meetings. I think until we have herd immunity, which Dr. Fauci says 75, 80%, and we have a little longer run, I don't think that just because you've been vaccinated means that you're out from underneath existing policies with regards to having your temperature taken, wearing a mask, and social distancing and hand washing and all those. Folks, we're going to have to continue to be vigilant, and you're going to have to continue to follow those protocols. So what about if you opt for a voluntary policy, you decide that you don't want to go mandatory right out of the gate, change your mind. A lot of the legal issues flow from having mandatory policies, and Mark will be talking about that in just a minute. But here's what I think you would need to have in a voluntary policy, very simple, is to make the case for vaccination. Tell your employees why you think that they should be vaccinated. That doesn't make you liable if there are side effects or if there are issues. Just take the CDC's statements, the FDA, and educate your employees. I think we're all in this together, and you have an opportunity to be an influencer with regard to your employees. So encourage them and help facilitate. Think of what we do with flu shots. We have a flu shot day. You may want to do that. Make it available at your place of work. You can perhaps pay for the shot. Okay to track who's vaccinated, but keep in mind that that is protected medical information, protected health information under the ADA. So you should keep that secure and not share it with other employees. Have some paperwork. Have folks indicate whether they're accepting the vaccine or whether they're refusing it. You can do that. You can also have a mandatory policy. The EEOC just yesterday issued some guidance. So if you go on the EEOC's website, if you're interested in this and want to do some further reading, they have had up and running for quite a while a section dealing with COVID. And just yesterday, they added some Q&As with regards to the vaccines and vaccination policies. One of the questions that's been out there, very simple: can an employer mandate vaccination? Can you tell your employees you must get vaccinated? Yes, you can. The EEOC has not prohibited that. The FDA and the CDC certainly have not prohibited it. You can do that. But again, understand that these vaccines have been issued, the one from Pfizer and the one now coming online tomorrow, perhaps from Moderna, under emergency use authorization. And that has some employers just having kind of a wait and see type attitude. But if you decide to go with a mandatory vaccination, if you decide to go that route, understand that you cannot have necessarily an across the board application of the vaccination policy. There are a couple of exceptions, and the EEOC addressed those exceptions as recently as yesterday when they put out this new guidance. It has to do with whether employees have medical issues, have some kind of an underlying disability, and then we have the religious exemption, which seems a little bit exotic, but we're going to spend a little bit of time talking about that. So Mark, why don't you tell us first about the medical exemption and what our audience needs to look out for there.
Thanks, Brian. I'd be happy to. Again, if an employer chooses to go the route of a mandatory vaccine, and that's where these would be the two elephants in the room, an employee claiming some kind of exemption because of a medical or religious issue. Again, as Brian mentioned, that would not be an issue under a voluntary policy. But let's look at the medical exemption a little bit. And I have, in drafting these slides, I was cognizant of the ADA and its state equivalent, Human Rights Act, protect a bona fide disability. And that's not the term that I've used in this slide, mainly for issue spotting purposes. The AD Amendments Act, the ADAA back in 2008, really broadened the term disability. And actually the stated purpose of it was to try and eliminate some of the fighting that employers and employees would do under what is considered a qualified disability under the Act. So just for issue spotting purposes for the medical exemption, I really want to hone in on if an employee comes and says, well, I can't take this vaccine. It needs to be for a medical reason. There has to be an underlying health issue. Pure apprehension. I can't take this, I don't want to take this vaccine because I don't trust it. I don't trust what's in it. I don't trust how quickly that we have gotten to a vaccine. I don't trust, I'm an anti-vaxxer essentially. You need to tease out just pure apprehension. If somebody comes to you with a medical reason, I can't take this because of an underlying issue, or there is an allergy, or there is a contraindication, that is going to at least begin to trigger the reasonable accommodation interactive process under the ADA. And what I would counsel, what I'm going to be counseling employers to do is if somebody comes to you with a actual medical sounding reason, then it's time to begin. You can inquire further into it. And I would advise asking them to visit their physician, their healthcare provider, and begin collecting documentation on what this medical reason is and how it interplays with the vaccine, so that you can begin to make some informed choices under the reasonable accommodation process that you are now required to undergo because they have brought to you a medical condition. So what does that reasonable accommodation look like? It's going to be a very similar analysis to what employers are already familiar with. You have to identify accommodations. Of course, in some cases, in some jobs, office jobs, I know my job, working remotely could be a very easy accommodation to provide. In other instances, and this is going to be fact specific to the position and the job duties that the individual is in, simple work, not everybody can work from home. Not everybody can work remotely. Not everybody can be physically apart. So when you start identifying accommodations, you need to find ones that will work unless you can show that there is an undue hardship. And in the ADA realm, the disability accommodation realm, that's a fairly high bar. It's defined as a significant difficulty or expense on the employer to excuse the employer from providing an accommodation. And of course, leave could be an accommodation. Unpaid leave could be an accommodation. As Bryan mentioned, yesterday, the EEOC announced some guidance on vaccinations, and they brought up the idea of a direct threat. So if you have been through the process, you have not identified accommodations that will work or that they would cause an undue hardship on the employer, the ADA has invoked the direct threat analysis. So under the ADA analysis, the employer has to show under the direct threat analysis that there is a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by a reasonable accommodation. And this is a very circular analysis. There are 4 factors, and it is individualized to the employee. The duration of the risk, the nature of the risk, the likelihood of potential harm, and the imminence of potential harm. But in the EEOC's guidance, they have stated that a conclusion that there is a direct threat would include a determination that an unvaccinated individual will expose others to the virus at the worksite. So if you have gone through the analysis, there is no reasonable accommodation that would work, or there is an undue hardship, you have to also consider the direct threat analysis before you can exclude an employee from the workplace.
Mark, if I could say a couple words here.
Absolutely.
You obviously, folks, only get into these issues of the medical exemption if you have a mandatory policy. If you have a voluntary policy, then you really shouldn't be having discussions with employees about why they're not getting the vaccine or what issues they may have. If it's voluntary, it's voluntary. And so there's no reason to be drawn into a discussion, really. But to Mark's point about documentation, you most assuredly can require documentation. And in order to trigger the ADA, technically, there has to be, the medical situation has to be a disability. Mark is absolutely right. At the federal level, especially, and somewhat at the state, they've loosened up on what is a disability. I mean, tens of millions of Americans qualify as having one type or another of a disability. So you shouldn't get too fixated on that. But you all have, you've been dealing with these issues under the ADA for a generation now. So most of you are fairly familiar. You may also be familiar with some of these issues because if you are in healthcare, for example, you may already have a mandatory policy. you may have a mandatory policy with regards to flu shots. And frankly, the EEOC and the courts will be looking a lot to precedent under the that came about under the flu policy. And the policies with regards, or the law with regards to flu vaccinations, is pretty much the same as what we're seeing now with the COVID vaccine. And that is that you have the medical exemption, you have the religious exemption. I have a particular client name who has had a longstanding flu vaccination policy. And one of the things that they did in order to get the percentages up is that they stopped accepting general practitioner or family doctor excuses. They said, look, if you're claiming a contraindication that you can't get a flu shot, then you need to go to a board certified physician who specializes in these issues. And that's who you need to go to. And you need to go through a test and determine. Well, I don't think we're quite there with regards to the COVID vaccination shots, but look for there to be some abuse with folks trying to take what is personal preference, or as Mark indicated, an anti-vax type philosophy. And they're going to try to slide it in underneath of the medical exemption. I think you will also see some out there around the state and maybe around the nation. You're going to see some employees, quote unquote, get religion because of requirements to get vaccinated. And we'll talk about that next. Mark?
Mm-hmm. Thanks, Brian. Yeah, as I see in with many of my clients, employees tend to get religion sometimes when a job requirement is inconvenient or objectionable for some other way. And we believe that the vaccination is going to be no different. So the religious exemption under the Title VII, I'm sorry, not under the ADA, is, as Brian mentioned, is a bit of an exotic analysis. It is akin to the ADA analysis, but there are some significant differences. So what you have to accommodate is under the Title VII and under the Human Rights Act for the religious exemption is a sincerely held religious belief. And that gets into a very deep quagmire of what exactly constitutes a religious belief. Obviously traditional religions would fall underneath that, but there could be the so-called online church, the Church of One, or even religions that are not as established as typical, religions that we hear about every day. It can be an ethical or moral belief system as to what is right and wrong with which the employee holds with the sincerity that someone typically would hold a religious belief. Now, having said that, as broad a net as a religious belief can be, it's not completely unlimited. Is it a personal preference? Like, again, the anti-vaxxer. Is it, as best as I can put it into words, is it secular? I have a personal preference not to take this. Or is their belief due to some sort of outside system? The EEOC did, again, even though the net is quite broad, the EEOC has issued guidance several years ago with regard to flu vaccines informally, that it's probably unlikely that religious beliefs would incorporate a secular philosophical opposition to vaccination. So again, it's an exotic, very nebulous, very tough analysis to make. And again, courts are very wary to start diving into the waters of what is or what isn't a religion.
Mark, if I could jump in at this point, so folks, I would say that there's really you have three shots at this, or three decision points if someone comes to you with a religious objection to being vaccinated. And there are sincerely held religious beliefs out there on this subject. So I don't want to, Mark and I don't want to discount that. You just see some zaniness around the edges of this. But the first question is, well, is it truly a religion that's involved here, or as Mark said, is it secular or philosophical? And again, to echo what Mark said, courts hate to wade into that as to what is or isn't a religion. Then you get into the sincerely held belief. That can be difficult to disprove. Where a lot of these cases get resolved, and frankly get resolved to the employer's benefit, is on reasonable accommodation. And the court a number of times have held that, well, that's all good and well that that's your religion, but it appears that the employer just can't accommodate. And it's a lighter burden to accommodate than what you have under the ADA, and that's the de minimis standard that Mark has there at the bottom. Mark, anything else on that?
Well, and yes, as Bryan mentioned, the de minimis standard, just to kind of put it in colloquial language, that has been held by courts to be trivial. If it's a trivial burden, then that absolves an employer from accommodating the religion. That doesn't mean it's non-existent, but it is quite a lower bar than the, quote, significant expense analysis under the ADA. For as long as the de minimis standard exists, although the EEOC won't change overnight with the Biden administration, there have been rumblings to bring the religious exemption accommodation standard closer in line with the ADA. And that's, again, I'm projecting down the pipe, but I would not be surprised to see the de minimis standard go away in the next few years.
Yeah, and just one point further, Mark, on the de minimis standard. So in essence, what the EEOC and what the courts have been saying up to this point is that you as an employer may be required to do something, rearrange schedules, do this or that. But if it becomes more than a de minimis burden, a small burden, if it gets much above that, then you don't have the obligation to reasonably accommodate. You certainly don't have to do the backflips that you sometimes feel like you're going under the ADA. So why don't we go to just briefly unionized workforce. We want to save some time for questions. If you have a unionized workforce, I think the thing to keep your eye on here is, do you have a mandatory subject of bargaining when it comes to the vaccination policy? You really need to look at your collective bargaining agreement. Look at the management rights clause. How broad is it? The Trump NLRB has used a contract coverage standard, which has given a little more latitude to employers, but you also may want to look at past practice. But then I think it begs this question: if you have a union workforce and you're thinking about putting a mandatory vaccination policy in, then why not invite the union in and have a conversation? And that may fulfill your obligation to do bargaining. That's provided that you can make a mid-term change. But I think the wind is going to be at your back. If you truly need to have a mandatory policy in your union workforce, the union will cooperate with you, and I think will be on board as well. So just kind of close, Mark, by talking just briefly about safety and liability. And I'll jump to your last point, if I may, on tort liability to third parties. You all may have been following this in Congress, and it looks like Mitch McConnell's insistence upon immunity from tort liability, that is injuries to the general public or customers as a result of COVID, has been stripped out of the stimulus bill. It doesn't look like that's going to happen. At least it's not going to happen with regards to this lane of Congress.
And I'll follow Bryan by working from the bottom up, since the workers' compensation also touches on vaccines that we've been talking about. As you know, the grand bargain of workers' compensation is that employees cannot sue their employers for injuries or illnesses in the workplace, except under very specific standards, the deliberate intent standard, which is very high. So how does that play with vaccines and their potential side effects? If a employer chooses to adopt a mandatory policy, then I think that would fall under the scope of employment if side effects were to show themselves. So if there is a mandatory policy and there is some sort of side effect that the employee suffers because of the vaccine, then that would probably shunt any claim into the workers' compensation system. Now, versus a voluntary vaccination policy, of course, there would be no liability at all, except for potentially deliberate intent. But I just really don't think side effects from a vaccine are going to get there under a voluntary policy for the deliberate intent standard or even a mandatory one. Not mentioned here, what about workplace infections? Well, as we all know, contact tracing has been a big thing in the news, and some of you may have been subjected to it. Again, it all goes back to what is within the scope of the employment. I think to get into the workers' compensation system based on an infection, then that would have to be contact traced back to the workplace. And just as we move forward, what are some other things that are out there? Workplace safety. OSHA is still out there. OSHA has stated that their standards still apply during COVID. There are no exceptions to this, including the if you are an employer who goes through the PPE program, and that is again not suggesting masks while you're in the building. There is a whole separate standard for that, but those still apply if you are one of those employers who has a PPE program and policy that's OSHA compliant. But one thing to look out for is the general duty clause. Of course, OSHA requires that employers just generally provide a safe workplace for their employees. Just yesterday, it didn't specifically touch on COVID, but yesterday, OSHA issued an edict that they were going to ramp up inspection and enforcement efforts on employers that have, quote, the highest rates of injuries and illnesses. So just know that the general duty clause is out there. There have been, and what would fall under that would be things like social distancing, plastic barriers, sanitizers, some of those just common sense things that a lot of you I know are already doing in your workplace to protect your employees. One thing that we will probably see toward the end of January into February under a Biden administration will be an OSHA emergency temporary standard relating to vaccines and relating to COVID in general. So far, the current administration has not done that. We expect to see that done federally and fairly soon. And I will note that some of states are starting to step up to that. California's state level OSHA analog issued a temporary standard effective on the 1st of December. If you are in California, you are required to have a written COVID plan. There are record keeping requirements, reporting requirements. You have to provide free testing to your employees. And if employees are exposed, then they have to be excluded from the workplace for 14 days with pay. So again, will a federal standard go that far under the Biden administration? I don't know, but I would stay tuned in late January, February to see if OSHA has something to say specific to COVID. So in the theme of what's coming and what's next, I know we've already touched on this, but I'm going to pass it back to Bryan for some final thoughts.
Well, the month of January is going to be a very interesting time on a number of fronts. On January 3, we have the new Congress that comes in. They actually come into office earlier than the president. January 5, as I mentioned, we have the Georgia runoff that's going to tell us who controls the U.S. Senate. And then January 6th, Electoral College results are received by the new Congress. And then, of course, on January 20, President-elect Biden will be sworn in. So a lot of change coming in the month of January, all while we're dealing with what probably will be record numbers with regards to this awful virus. So why don't we stop there? Congress will stop tomorrow, so we'll know this evening or tomorrow, Mr. Dayton, what Congress has done on this front. And I think we have time for a little bit, some questions, and we're happy to even stay over past the top of the hour.
Sure. Well, thank you. And just to follow along that train of thought, we are encouraging all of our members to reach out to all 5 members of our delegation and urge them, to support additional COVID relief before the end of the year. So I know it's been good news that the leaders of both houses are sitting down together, but we're again encouraging our members to make sure that our delegation knows how important this is to the business community. So appreciate you guys taking some time for Q&A. Just for anyone on the call, if you want to go ahead and have a question, type it into that Q&A box. And I don't know that we'll be able to get to all of them. So let me just ask real quickly, those questions we don't have time to cover today, would you like people to email them to me and me to forward them to you guys, or would you prefer if they email them directly to you? How would you like to handle that?
They can do it either way, Brian. They can send it to you, or they can just email directly to
Sure.
myself. Happy to help.
Well, that sounds good. The first question, we spent some time on the mandatory versus, voluntary vaccination program. Can a company decide to make some positions mandatory based on whether or not, for example, an employee interacts with the public and others voluntary? Do you have any thoughts on that, or does it need to be uniform?
No, I don't think it needs to be uniform, as long as you're not discriminating on the basis of some prohibited classification. I think you can make it mandatory for some positions and not mandatory for others. A classic would be in a healthcare setting. You may have somebody who's in the back of the house, never sees patients, and they may not have that requirement, whereas somebody in direct patient care, you may want to require. And I think you can do that. I think you can pick and choose between.
Thank you. Another question we've had, this came in via email. If an employer makes the vaccines mandatory, does that employer need to pay the employee for the time it's required to go get a vaccination? And kind of a supplemental question to that, let's say that the employee has side effects that would preclude them from coming to work the following day. Does the employer need to pay that employee if it's a mandatory vaccination policy?
Let me go in reverse order. Technically, no. If you're having side effects, because even though it might be a workers' comp covered incident, if they're having side effects, as I think most folks know, you have to be off work for 3 days in order to get wage loss protection. So if you're off for just 1 day, that's not going to be covered by workers' comp. Now they may be eligible under your policies, sick leave, but that's just the normal policies that you have. I think it would certainly be a great practice for employers to do that if somebody's having side effects, cover that and not charge it against the sick leave bank. But technically, I don't think they're required to do that. Now, with regards to the other question of, does an employer have to pay employee for the time? Certainly if you're doing it during work hours, you don't want to have a situation where folks are punching out, getting their shots, and then punching back in. You want to pay them for that. But if it's, I view it as it's a close call, but I think if you're using a third party and you just say, look, you need to go get vaccinated at some point, it's like a lot of things that we have to do that are work related, and I don't think that you would necessarily have to pay for that. But if it becomes something that's a burden, then you may. I know I have one client who has opted to just pay everybody an hour. But they're having it done at the beginning or at the end of work shifts. So that's a little bit different, and they're just paying folks an extra hour to do it. Mark, any thoughts on that?
Just to hone in again, Brian, on your point that actually there can be 2 different flavors of the mandatory vaccine policy. One is employer facilitated at work during work hours. Perhaps you contract somebody to come in and do the shot in a conference room or something. The other flavor could be, go to Rite Aid or go to MedExpress and get your shot and just present us with proof of your vaccination. And each of those are going to come with different considerations that I'm not sure we'll have complete time to cover, but I just wanted to emphasize your point, Brian, that there really are two flavors here of mandatory vaccinations.
Thank you. The next question we had comes from a healthcare provider, and their question was, they said they have employees who are out right now due to a positive COVID test, but they're not sick, they're not symptomatic. That employer is asking, can they make them return or not pay them for the time off through the EPSLA if they're not symptomatic and just have a positive test? They said, they followed up, said they know that as a healthcare provider, they didn't have to do the 80-hour through the CARES Act. And I know some of this has kind of changed, as we've learned more about COVID, just throughout the year. But do you have any thoughts on that?
Go to the CDC website. I think the CDC has issued some guidance with regards to asymptomatic healthcare providers who've tested positive as to how long you need to wait and what kind of PPE the individual needs to be wearing. And of course, most of you know the CDC has changed the guidance with regards to quarantine. It's now 10 days instead of 14 days if you're not showing any symptoms, and then 7 days if you're not showing any symptoms and you've had a negative test. That's with regards to exposure. Obviously, with regards to a positive, I think it's still 10 days. But back when, especially when things when healthcare providers have really been up against it, the CDC made some allowance for asymptomatic employees a little earlier than one might expect. It's on the CDC website.
I'll add, Brian, that I would also check with the Division of Labor. Again, we're only about 2 weeks till the end of this, but the Division of Labor had some slightly different rules for healthcare providers. So I would check there are exemptions from the FFCRA, and the healthcare providers play by slightly different rules. So I would also check the DOL for the next 2 weeks to see what their most recent guidance is on that.
United States Department of Labor.
Yeah.
The next question we had come in, and I know you guys touched on this a little bit about, reasonable accommodations. Is there any kind of idea right now on how long an employer would need to provide those reasonable accommodations as we move through 2021?
Reasonable accommodations with regards to vaccinations? Yeah.
Yes. Mm-hmm.
Well, it's an interesting question, Brian, because one of the factors in assessing whether an employer can reasonably accommodate is how many folks have been vaccinated. So it's going to be a little bit of a sliding scale. If an employer has an interest, as does the rest of the country, in getting the numbers up, then you may be less inclined to reasonably accommodate, and you may have less of a burden to reasonably accommodate. But if we get to a situation where 95%, or you have just about everybody in your workforce who's been vaccinated, and we've stopped the spread, and then you have that one person or three people that, for whatever reason, whether it's religious or medical, don't want to get vaccinated, you may have a little bit more margin. In fact, you may have more obligation to reasonably accommodate them because the risk that they're adding to is not as great. We're definitely going to see the percentages of the workforce on vaccinations impact the reasonable accommodation analysis.
Thank you. And just the last question we'll go ahead and do, because I know we've reached the top of the hour and gone a little bit past that, but are employers allowed to ask for an employee's COVID-19 test results? Someone goes out and gets tested, can that employer verify whether it was a positive or a negative by getting the results?
Yes.
Okay, so no real risk of issues there.
Risk is if you are sharing that information with other employees, protected health information, and you need to, if you get paper, if you get documents, or you get an email, you need to segregate that in a separate file, and you need to protect the confidentiality of it.
Sure, but you can ask. Okay.
You can ask.
Well, Brian and Mark, we really, really appreciate you two taking time today to provide this webinar. Just for those who are still with us, we have recorded this and we will be uploading this and sharing it with our members as soon as that recording becomes available. It's a little bit dependent upon Zoom and how fast they get the file ready in the cloud. Along the vaccine info, we're going to be getting some information out from the chamber. We're in close contact with the governor's office and his COVID-19 task force, and they've actually sent us some good information sort of along the lines of debunking the myths related to the COVID-19 vaccine. So we'll be getting that information ready and sent out to all of our members so that you can have that information handy as you have discussions and so forth. But again, Brian, Mark, really appreciate your time today. And I want to thank everybody who dialed in for this very important webinar. We're coming upon the end of the year. So for those of you who we don't have a chance to talk to again, hope you have a happy holidays, stay safe and stay healthy. Thank you.